Good afternoon. Welcome to our second Ask Ashfords Q&A session, which today is on misconduct, disciplinaries and dismissals. Unfortunately, Kirsty Cook, who usually co-hosts these with me, has been unable to join us today. So I've recruited the fabulous Charles Pallot, who is a partner in the team, to impart his extensive knowledge in this area with me.
That's quite an intro, so thank you.
So just in terms of housekeeping first, to assist with connection issues, please keep cameras and microphones switched off. We'll use the chat function on Teams to encourage any comments and questions as we go through. We are recording the session today. I've been told I need to let you know that. We've allowed 45 minutes for the session. I know everyone's very busy at the moment, so we'll do our best to stick to that. We've had a few questions sent to us in advance, which we'll be going through. Where some are similar to others we've received, we've tried to broadly categorise them. But if you haven't had a chance to send them in advance and you've got a particularly thorny issue, or even a simple one, that you want us to address, pop it in the chat box, and if there's time at the end, we'll try to get to it. Please bear in mind that we won't be able to address questions which are too fact specific, but if you do have one that perhaps falls into that category, do get in touch with us directly, with Charles or I, and we'll do our best to help you outside of today's session. So let's get started. Before we actually get going with the questions, I wanted to very briefly look at a couple of the key concepts that come up in misconduct, disciplinaries and dismissals. And this is pretty basic employment law 101 stuff, but I make no apologies for that, because they're concepts which are relevant to all of the trickier questions that come up. And if you can really keep these points in the back of your mind, it's going to be easier to navigate new factual scenarios as they arise. So I think we all know that misconduct is one of the potentially fair reasons for dismissal. But whether that dismissal is in fact fair or unfair will turn on whether the employment tribunal considers that the employer has acted reasonably in the circumstances in treating the misconduct as a sufficient reason for dismissing the employee. So each case has to be looked at on its particular facts, and we can draw some general principles from the case law, but the decisions themselves can generally only be treated as examples, and they're not actually establishing that a particular type of misconduct does or doesn't justify dismissal. So the test, which you're probably familiar with, of whether the dismissal was fair is whether the dismissal fell within the range of reasonable responses of a reasonable employer in all of the circumstances. So the dismissal will be unfair only if the employer's dismissal was outside of this range, this band of reasonable responses. So the tribunal isn't asking whether it would have dismissed in those circumstances, but whether another reasonable employer in all the circumstances would have done so. And there's a well-established three-part test, which we know as the Birchall guidelines, which an employment tribunal must consider. And the range of reasonable responses test applies to all three parts of that test, which are: number one, did the employer genuinely believe that the employee had been guilty of the misconduct at the time it dismissed him? Number two, if so, were there reasonable grounds for that belief? And number three, did the employer carry out as much investigation into the matter as was reasonable in all the circumstances before dismissing the employee? So that range of reasonable responses test and those Birchall guidelines are the points that I want you to keep in the back of your mind as we move through all of these questions. So I'm going to start with a question that I'm going to ask Charles to look at. Can an employer fairly dismiss an employee for an act which takes place outside of work? Over to you, Charles.
Thanks, Sue. All I would really add to what Sue's excellent introduction summary is to say that the way in which an in particular employer behaved in any disciplinary or dismissal process will take into account the size and administrative resources open to the employer, and that will govern a lot of procedural points which can be tricky in disciplinary and dismissal procedures. For example, where an employer has a fairly flat management structure and can't reach the ideal of having, for example, different levels of management at different stages of the process, such as investigation, disciplinary, and appeal. So bear that in mind as we look at these questions as well. So this issue of whether you can dismiss someone for something that happens outside the context of work remains a hot topic. I think it's fair to say, particularly where social media means that all of our lives are in theory on public view, even at private events or outside of work. So in theory, yes, an employer can fairly dismiss an employee for an act which takes place outside work, but each case is going to be very fact specific, taking into account the three virtual tests which Sue explained at the beginning of our meeting. You also need to consider, rather than just a knee-jerk reaction of someone's done something bad outside work, therefore we've got grounds to dismiss them, you must adopt a slightly more scientific approach and consider the effect of that alleged misconduct in relation to issues such as the suitability of the employee to do his or her job and how the misconduct affects that. So, for example, you could find yourself in a situation where you offer an advice service and the employee is alleged to have done something which counteracts the advice which you give your service users. It's the effect of that behavior on the relationship between you and that employee, or between that employee and their colleagues and customers and service users. So this is an issue very much of trust. If an employee's done this outside of work, can we trust them to continue? Can we trust them to maintain our confidence in them and the confidence of our customers and service users? But also, and thirdly, of course, the impact on your business's reputation. This is something which you need to think about carefully and ideally have some evidence to back up your concerns that if we are found to continue to employ an employee who's done this, that's going to result in our losing customers, clients, or potential funding issues. So you need to consider also the nature of the incident. What was it? Was it dishonesty? Was it violence? Was it a crime? Is it wholly against the precepts and ethos of your business? Consider also the nature of the work which the person does and their role within the business. Are they a junior person, or do they act in a position of trust, or perhaps with vulnerable service users? Does their work also include in contact with the general public and potential users of your business? The more senior they are, the more conduct outside work is going to impact on their ability to continue satisfactorily in doing their job. So once you've assessed all of these points and you've determined that this all points to the act affecting their suitability to do their job, then you can, with a degree of confidence, start a fair investigation process and, of course, give the employer the opportunity to respond appropriately at a disciplinary hearing. The usual principles apply. So the message really is think carefully about whether it is as serious as it first looks, and think carefully about the impact of on your business and your staff and your customers of this alleged misconduct. There's an additional level of complexity where the misconduct attracts criminal charges or convictions. Just wanted to raise really 2 points about that at this stage. The first is that you will often want to liaise with the police in relation to their investigations and yours, because you won't want the police to accuse you of prejudicing their investigations. It may be, for example, that the police will want to speak to the employee first before you put any allegations to them. And it may be on occasions that the police will be prepared to share evidence with you. Maybe it depends entirely on the police force and the circumstances of the case, which will help you run your disciplinary process. Some clients sometimes ask us, what happens if the person's arrested, but actually the case is dropped against the employee for lack of evidence. Now, this won't necessarily mean that you can't proceed with your disciplinary process if, taking into account everything that you know and the concerns that have been raised with you, you still feel it's appropriate to continue with your disciplinary process. And this is because primarily the standard of what we call the standard of proof in criminal proceedings is very different from the standard of proof which you would be required to show to a tribunal in an employment tribunal claim. So to get home on a criminal conviction, the prosecution have to persuade the jury or the magistrate, depending on the level of seriousness, that the employee was guilty, that the person was guilty beyond reasonable doubt of the offence that's put before them. In a disciplinary context, however, you only have to be more satisfied that it's more likely than not that the employee was guilty of that particular offence. So that's a much lower burden of proof. And so in summary, the fact that the police have decided not to pursue, or the CPS have decided not to pursue the offence, does not mean that you should then at the same time automatically stop your disciplinary process.
Thank you, Charles. Okay, next question that's come in is, what should an employer do if an employee who is subject to a disciplinary process raises a grievance? Now, this is a really common one. I'm sure most of you have faced this in the past. My opening comment, though, is try to hide involuntary cynicism. It's very easy and indeed natural to assume that an employee subject to allegations will do all that's necessary to save their skin. But we need to try to hide that thought away and keep an open mind. That gut instinct might be right, but it might be wrong. So we mustn't assume anything. The real issue for us will be how the grievance is going to affect the disciplinary process. So let's start with the ACAS Code of Practice, a very good place to start. And they state that where an employee raises a grievance during a disciplinary process, the disciplinary process may be temporarily suspended in order to deal with the grievance, or where the grievance and disciplinary cases are related, it might be appropriate to deal with both issues concurrently, i.e. in the course of the same hearing under the disciplinary process. But what's really important is the Code of Practice doesn't require an employer to do either of those things. They're merely suggestions of what may, that's the terminology that's used, may be appropriate in some circumstances. The key issue for you is likely to be whether or not you handled the disciplinary issue fairly, taking into account the nature of the employee's grievance and the way it's dealt with. So, first off, get to grips with the nature of the grievance. What is alleged? Now, looking at when it might be appropriate to temporarily suspend the disciplinary process, the ACAS code gives the examples of the grievance being relating to a conflict of interest that the manager holding the disciplinary meeting is alleged to have, that there's bias alleged in the conduct of the disciplinary meeting, or the management have been selective in the evidence they've supplied to the manager holding the meeting. I'm not sure I completely agree with that. I think it could be overcautious. Bear it in mind, have that as your starting point. But like I say, it's always fact specific. So in the first case of alleged conflict, you can simply write to the employee saying you don't agree, but you'll switch managers if that's a possibility for you. Similarly, allegation of bias, you could either swap managers or conduct a really quick but robust grievance process whereby the employee is asked to give reasons for alleging bias, the manager is asked to comment, and a decision is taken. If the allegation is that the management is being selective with evidence, then again, this can be dealt with as part of the disciplinary, either by carrying out further investigations to obtain the evidence the employee says is being withheld, or having it as a ground of appeal if it's still an issue at that point. So good guidance from ACAS, but let's not be too overcautious with these things. So next, when might it be appropriate to consider the grievance concurrently as part of the ongoing disciplinary? Well, that's often the right thing to do, as in effect, often the employee's allegations in the grievance are actually their defence to the allegations in the disciplinary. They're an explanation for what they did. So if you are going to deal with the grievance and disciplinary together, though, you need to give each aspect the attention that it needs. You still need to deal with that grievance, and there are processes that you need to follow. So while the issues might overlap, don't be complacent about the steps you need to take properly with the grievance and the disciplinary. You need to make sure that the employee knows exactly what's happening, investigate properly, give the employee time to prepare before the meeting, and don't be tempted to rush through just to stick to the original hearing date. Be prepared to push things back if need be, but don't let things slip away. Keep on top of the timing. Make sure that the grievance doesn't hold things up unnecessarily and isn't used as a delaying tactic. Finally, there's the possibility that the grievance is completely unrelated to the disciplinary, to the extent that the outcome of the grievance isn't going to affect the outcome of the disciplinary, in which case it might be appropriate to run each separate process in parallel. It won't matter if one takes longer than the other. There is no requirement for the grievance process to be completed before a disciplinary is taken. So you need to look at each grievance that's raised within the context of the disciplinary to decide which of those options you want to go with. Right, Charles, over to you for the next question.
Thanks, Sue. I just to add what you say, I think just picking up from the point that you've made, it's a common tactic that employment lawyers and HR specialists are familiar with of an employee at the receiving end of a disciplinary, which they know is kind of bang to rights, to throw every procedural stone under the wheels, if you like, to try and stop the process moving forward to a sensible conclusion. And if there are the points which the employee is raising can be dealt with easily without much prejudice to you, then there's something to be said for just agreeing to what the employee wants to happen, so that it's one less stick for the employee to beat you with if you get to an unfair dismissal claim. But it's each concern, whether in the form of a grievance, formal or otherwise, should be considered carefully within the context of the overall disciplinary. So my next question is, how should we deal with an employee who makes allegations against another employee but wants to remain anonymous? If I were to ask people to put their hands up and I could see what you were doing, I'm sure the majority of you would have faced that very sensitive issue. So the starting point is that the basic principle, one of the basic principles of a fair disciplinary process, is that the employee is entitled to know the allegations against them and to see the evidence in support of those allegations, so that they can have the opportunity of challenging that evidence. And it can often be difficult, of course, to present that evidence without disclosing the identity of the person who made the complaint. So if, for example, the allegation is Jim comes to you and says to you that Mary kicked him really hard in the leg, and you want to raise a formal complaint about her to be taken to a disciplinary process, but you want to remain anonymous, it would be very difficult in your conversation with the employee to be able to present any evidence of that allegation to the employee without Mary knowing that it was Jim who made the complaint. So there are some guidance around this point, some of which has been proposed by the Employment Appeal Tribunal. It recommends that you should first of all take a formal statement from the accuser, finding out what they saw, what they did, and so on, and keep that as a record. As with all these things, if you're potentially facing legal action, it's as good to have a record justifying what is important to have a record justifying the actions and steps that you took. Consider then whether you can carry out any further investigations with a view to corroborating or undermining the accuser's evidence. Because of course it might be the fact that in this particular instance, Jim's getting his defence in early because Mary kicked him because of something he did to her or said to her. So it will also assist with in certain circumstances, maintaining anonymity if there were other witnesses who you could interview about the incident, and then it'll become less clear to the employee in certain circumstances who actually started making the complaint. You should then make your decision based on your view of the strength of the evidence, whether or not to proceed with the disciplinary process. The EAT also suggests that the anonymous employee's written statement should be made available to the accused employee with any identifying details removed. My view is that that can be slightly optimistic when it's going to be, in some cases, fairly obvious that only person X could have made that statement. So the advice there always is, if the employee is reluctant, the accusing employee is reluctant to make the statement, then you need to discuss with them what the consequences would be in terms of the options which are available to you as an employer. So if you form the view that you can't proceed with a fair disciplinary process without the benefit of that person's statement because there were no other witnesses, no documentary evidence, nothing else, you would struggle to conduct a fair disciplinary process with that employee, essentially presenting the other employee because you would be presenting them with no evidence. So that may be a technique that you might want to use. And finally, if at the disciplinary hearing the accused raises any questions about the evidence, the hearing could be adjourned to allow those questions to be put to the accuser outside of the context of the disciplinary process. And I've seen this done in writing as being one way round the wish of the accuser not to be involved in the disciplinary process in any real way or be identified. And the same issues apply to witnesses in an investigation who also wish to remain anonymous. One other point to raise here is that we all dread the case of an employee coming to us saying, I have been sexually harassed by so-and-so. I just wanted you to know, but I don't want you to do anything about it. And I think he's a bit of a creep. Your concern, of course, then is for the health and safety and welfare of your other, say, female employees, because you're now on notice as an employer that something is not right. But with only this person coming to you to making a complaint and not wanting anything done about it at all, leaves you in a very difficult position. So one technique around that is to discuss the situation in detail with the employee and to reassure them that you understand the position. Say to them that this is something, this kind of behavior is obviously something that the business does not support, tolerate, or accept. And that if, however, the business is going to be able to do something about it, somebody needs to come forward and be brave enough to come forward and, awful phrase, put the head above the parapet. And it may be worth exploring with that person also whether they're aware of any other employees who've been on the receiving end of this rather odd behaviour, the sexual harassment by this particular employee. And it may be that people then feel more confident in a group coming forward to make a complaint rather than risk being the ones themselves who are on their own and are very nervous about what will happen to them, particularly if the allegation isn't upheld, because it would be, many female employees in that situation feel, well, it's going to be on a he said, she said, no one else was there. So I could go through this, put myself through this awful process and then find that nothing actually happens as a result of it. So there is often in that situation an advantage to other people coming forward as well to give the employee confidence. Sue.
Thanks, Charles. So next question, what is the best approach to managing misconduct when mental health issues are cited as the reason for the misconduct? I think we've got another question later on where, which I think is more likely to come up for many of you, where mental health issues cause someone to go off sick during a disciplinary process, but we'll come on to that. So this is a case where the employee is saying that their mental health issues are the reason for the misconduct. Now, it's important to remember most employers are not mental health professionals. So chances are you're going to have to seek expert advice. You'll need to get the employee's permission to refer them to occupational health and to get a report which can be shared with you. But it isn't a good idea to make just a general referral to occupational health using their standard form. In fact, it's rarely a good idea to do that when you're going to OH. You need specific answers here, and the best way to get specific answers is to ask specific questions. So, for example, you might want to ask, the employee has explained that their depression and anxiety has caused them to have outbursts in the workplace and use bad language towards their colleagues. Can you explain whether or not that is the likely reason for their behaviour? Is there any way we can support them to avoid this sort of behaviour in the workplace in the future? So by asking those specific questions, hopefully you should get the information, whichever way that is necessary to determine in the disciplinary whether that should be taken into account. So you get your report back, and you might be in a situation where the report says that the employee's mental health is unlikely to be the reason, in which case you can proceed with the disciplinary. If the report says that it is likely to be the reason, then of course you can't just ignore that. You're going to have to consider that medical advice very carefully, including any reasonable adjustments that they suggest. You'll need to consider whether, based on the medical evidence you have and all the other circumstances in the case, it's still going to be fair to dismiss, or whether you can put in place adjustments that would avoid a repeat of that behaviour. If, despite taking on board that medical advice, despite putting in place the adjustments, the unacceptable conduct continues, then you're likely to be in a better position to escalate that disciplinary process further. So that was a relatively quick one. So back to you, Charles.
Thanks, Sue. So the question is, can multiple allegations of different types of misconduct add up to justify a summary dismissal under one disciplinary process, even though each allegation alone would not necessarily amount to gross misconduct? So to put that into context, summary dismissal is where you dismiss an employee without notice because they have fundamentally breached a central provision of the employment relationship. Most commonly, the underlying duty of and relationship of trust and confidence that must exist between employer and employee. And dismissal without notice is reserved traditionally for the most serious forms of misconduct, such as fraud, criminal activity in relation to the workplace, sexual harassment, or anything which undermines the trust and confidence, anything which the employee does, which means that the employer can no longer reasonably be expected to continue to employ this person. So that is the traditional route to dismissal without notice or summary dismissal. However, it is not impossible for a collection of individual disciplinary allegations, none of which of itself is serious enough to amount to justify summary termination, for those allegations in total to justify summary termination. In fact, there's no actual legal authority to suggest that there must be a single act amounting to gross misconduct. But nevertheless, we would always caution care taken in taking this approach without very specific advice about the facts of your case. One of the factors that you might want to take into account is that there have been so many instances of the employee refusing to comply with the principles and ethos of your organisation over a long period of time, that and has demonstrated in their misconduct an unwillingness to respect those values and ethos, that the stage is reached where you just think the employee's done so many things which added together mean that we are entitled to take the view that we have lost entire trust and confidence in that employee. And again, caution, each case is going to be fact specific. It is nevertheless a good idea to make sure that your disciplinary policy contains an option for you to do that. Final quick point on this issue A dismissal might be fair in these circumstances, following the tests that Sue set out, and you followed a fair procedure and so on. So you might end up with a finding, if your dismissal's challenged, as a fair dismissal, or the fairness of dismissal is challenged. However, a different court might find that the dismissal is what's called wrongful. And wrongful dismissal is a claim for essentially notice pay. It's not concerned with the process which the employer followed. What it's concerned with is looking at the situation entirely objectively. Was it appropriate for this employer to terminate that employee's employment without notice? So it is possible, in theory at least, for an employee to succeed in a claim for wrongful dismissal in those circumstances and fail in their unfair dismissal claim. Sue. I think you're on mute.
Can't believe after all this time I'm still on mute. Apologies. So I've bundled a few questions together for this one. What can we do if an employee fails to attend a disciplinary? Well, it really depends on the reasons why and the specific circumstances. So you're going to need to be quite careful using my examples here in your own situations. But let's look at some examples. If an employee says he needs more time to prepare, it's usually going to be advisable to give an extension for a few days, but after that, it should be fair to proceed. Having said that, it might be different if, for example, the allegations were financial fraud and there's a huge number of documents and technical information that needs assessing. In that case, it might be reasonable to give a longer extension if requested by the employee. If the reason that the employee fails to attend or is saying that they're not going to attend is that they need to ensure the availability of a representative, then there's a statutory right to postpone the hearing for up to 5 days. But the most common reason that we see, and I'm sure you've seen, that I want to focus on is where an employee, on being notified of disciplinary proceedings, is signed off sick, often with stress or reactive depression. So coming back to my comment I made before, it's important to try to bury that cynicism here and proceed with an open mind. Be patient, tolerant, sympathetic, but not at the expense of a proper process. Again, with this one, getting that expert medical advice is going to be key, and asking the right questions. So whilst an employee may be signed off as not fit to work, that doesn't necessarily mean that they're not going to be fit to respond to disciplinary allegations. So here, the key questions will be whether the employee is fit to attend a hearing, and if not, whether they're fit to respond to the allegations in some other way. Ask if there are adjustments that could be made to your policy to enable the employee to participate. For example, you might allow a friend or family member to accompany them instead of a trade union rep or colleague, or you might be willing to hold the hearing at their home. It's also worth asking the OH advisor whether the illness is as a result of the disciplinary. Because if the cause of the depression or the anxiety is the disciplinary hearing, then it's unlikely to improve whilst the disciplinary proceedings are outstanding. So a key question for OH will be, if the employee were to attend the disciplinary hearing, what effect would that have on their health? And on the flip side, what would be the likely effect on their health if the disciplinary process were to be prolonged by ongoing postponements or periods of inaction? The last thing you'll want to do is worsen their condition, because that raises all sorts of legal liability issues. So the fundamental question will be whether they are reasonably capable of responding to the disciplinary allegations. Assuming that OH says that they are, you can press ahead. Generally speaking, if you then give them, say, 3 opportunities to either attend or let someone else attend to make representations on their behalf or provide written representations, then you're going to give them a right of appeal. It would be pretty unusual for a tribunal to say that that sort of process falls outside the range of reasonable responses. If based on medical advice you do have to postpone, and that drags on indefinitely, there will come a time when you do need to make a decision. It's never ideal to hold a hearing in the employee's absence. But if you're sure that you've tolerated all the delay you can, and you have a compelling reason to hold the hearing at that time, then you're going to have to go for it. Obviously, first, offer to put in place the adjustments recommended by the medical experts and do your best to encourage the employee to attend. You could suggest holding the meeting at a different venue or by Zoom or telephone. Like I've said, they could be invited to send written submissions or have a companion attend on their behalf. But what's really important if you're going to press ahead is that you impress upon them the potential consequences. They need to know what the outcome might be, that might be dismissal, whether they attend the hearing or not. And they need to know that if they don't attend, you'll decide the outcome based on the evidence you have. So lots to consider there, and a lot is going to hinge on that referral you make. It's going to be a really key document, your OH referral, to make sure you get the answers you need to take the right course of action. Thanks, Charles. So
thank you. So I've got a quick one. Question is, what is your advice on taking into account expired warnings or similar conduct that hasn't led to a formal warning in the disciplinary process? So looking at expired warnings first, it can be fairly dangerous to take into account an expired warning. So say an employee was disciplined 2 years ago, had a warning on their file for a year, that warning expired, another year went by, and then the employee was guilty of similar misconduct. It would be dangerous to dismiss the employee on the strength of that previous written warning as it had actually expired, and in theory should have been expunged from the employee's file. I suppose that having been said, one of the issues that we look at when advising clients around the issue of, look, I'm in two minds about this employee. I'm aware that the purpose of a disciplinary process is not to penalise the employee, but to ensure that the correct standards of conduct are maintained. And this employee has fallen below those. I can't therefore really decide whether to dismiss them or give them another warning. One of the issues which you want to consider is whether you think that warning will have any impact on the employee's behaviour. And there are certain questions that you can ask during the course of the disciplinary process to help you understand whether a warning would have the desired impact. The answer to the questions could be, well, I don't see what all this fuss is about, in which case you might take the view that a warning is a waste of time and you wouldn't need to rely on the previous warning at all. If, however, the employee puts their hands up and says it was a slip and an error and whatever, and I promise I will behave again in the future, then you might consider that a warning might be appropriate again without relying on any previous warning. In relation to similar conduct that hasn't led to a formal warning in the past, again, you shouldn't really use that at all unless that similar conduct is being put to the employee and has been investigated as part of the disciplinary process. You shouldn't penalise people on the grounds of suspicions and so on which have not been raised with the employee.
Thanks, Charles. Another one, most of these questions are common ones you'll come across that come up a lot. So this one is, what process can I use to dismiss an employee for misconduct if they've got less than 2 years service? Now, we all know in employment law, 2 years is the magic number. Once an employee reaches 2 years service, he or she gets unfair dismissal protection. And so it's really tempting if an employee just isn't right for whatever reason, or if they've suspect that they've committed some misconduct, to simply dismiss, possibly with notice, depending on the severity of the allegation, but just to dismiss without following your full disciplinary process. Now, commercially, there's a view to be taken there. Disciplinary investigations and hearings take up a lot of management time. So if you deem the risk of a claim to be low, it is tempting and often appropriate to limit that process. But the danger is that there's a myriad of claims that can be brought following a dismissal which have no minimum service requirement. So you'll be familiar with allegations that the dismissal was discriminatory, that the dismissal was due to whistleblowing, or for raising health and safety concerns. And there's lots of others, and none of these need 2 years service. So when clients come to us with wanting to make short service dismissals, first thing we'll do is run through a checklist of potential claims that the employee may have that don't require long service. And if there is a potential risk identified, then we'd advise to go through a process regardless. But we've also seen a lot of cases where, despite the employer going through that checklist, the employer is satisfied that there's no risk, and so they've called that employee into a meeting and said, sorry, it's not working out, you're dismissed. They're not given a right to respond, not really told what the issue is in much detail, and they're given a dismissal letter that just tells them they're dismissed because they're not right, or it just hasn't worked out, or something quite vague, because the employer just doesn't want to become embroiled in a discussion for someone who's only been there 2 months. The trouble is, a few months later, you might get contacted by ACAS and face a claim for discrimination related to a protected characteristic that just hadn't crossed the mind of the employer. Chances are there hasn't been any discrimination, but by not going through something of a process and by not making the reason for dismissal clear, questions can then be raised over what the real reason for dismissal was. So in most cases, even if under 2 years service, and even if you don't think there is a real risk, I would still suggest meeting with the employee, explaining very clearly what the concerns are regarding his or her conduct, giving them a chance to respond. And then if you do dismiss, confirming the precise reasons why in writing. So you're not going through a full investigation and disciplinary hearing, but you have followed some form of process. And hopefully by going through that brief process, you've got a chance to uncover any potential risks before pulling the trigger, because hopefully the employee might say, oh, well, that was because of my disability or whatever, or my manager has been treating me badly because of my race, or whatever it might be. It might uncover those things. Hopefully you get the opportunity to avoid most claims because the employee knows why they've been dismissed. And if you're still facing a tribunal, you've got good evidence in that dismissal letter of why you dismissed, and that's going to be helpful in defending any claims. We did have 2 more questions we've received. I don't think there's any in the chat box. I am conscious of time. Charles, I'm happy to stay on for an extra 5 minutes.
Yes, of course.
If others, feel free to drop off, of course. We did have 2 more points we wanted to cover, so we'll carry on. And if there's no one left by the when we're still talking, then we'll finish. But I'll just crack on for now. So the next question I'll look at as well is how do I, it's an interesting one. How do I determine what level of sanction is appropriate for a given offence? So you've carried out your reasonable investigation. You've found that on the balance of probabilities, those allegations are proven. But how do you actually decide what level of sanction is appropriate? So generally speaking, there's a number of criteria that will help you determine the most appropriate level of sanction to use in any particular instance. So we need to look at the severity of the offence, the employee's past performance record, length of service, your past practice in dealing with similar infractions, and any other mitigation. I just want to look a bit more closely, because I think this one gets a bit confused, about your past practice in dealing with similar infractions. Just remember that while you're responsible for treating like cases alike and ensuring consistency, it doesn't mean that you necessarily have to treat everyone the same. And the other criteria I mentioned about past performance, length of service comes into that. So, for example, an employee caught sleeping at his desk might receive a verbal warning if he's a long-term employee with an excellent track record, whereas an employee in his probationary period might be given a written or even a final written warning for the same offence. I'm going to assume, for the purposes of this question, that during the investigation, you haven't discovered an underlying reason for the falling asleep.
No narcolepsy.
No, exactly. We also need to look at the context of the offence. I'm going to stick with this sleeping on the job example. So let's say we're in a hospital setting and you've got a finance assistant sleeping at his desk. He might receive a written warning. A nurse on the night shift who's responsible for ensuring patient care and safety might be placed on a final written warning for the same offence. But at the extreme, an anesthesiologist, difficult for me to say, sleeping in the operating room might be summarily dismissed because it's those circumstances surrounding the act of sleeping on the job that will play a crucial role in determining what sanction is appropriate for essentially the same offence. Another point which Charles has alluded to is how the employee reacts to the allegation. Have they admitted it, taken accountability, showed remorse? And those factors might impact on your decision whether dismissal is the only option or whether you're confident that given another chance, they would not repeat the offence. And this is Charles's favourite killer question that he often advises, is at the end of a disciplinary, where if the employer is trying to decide between dismissal and a final written warning, ask the employee, what can you do? What can you say to me today, right here, now, that's going to convince me that that's not going to happen again? And their response to that question could be the tipping point on which way you go and could be the key to justifying, in the view of the tribunal, whether or not a resulting dismissal is fair. So, final question to you, Charles. There's nothing in the chat box, so we're not going to be put on the spot today.
I just wanted to add, one other to share with our friends on the call today, the other extreme example of the sleeping on the job situation. And it's interesting when you say you imagine a scenario, someone is sleeping at work, someone comes rushing into you at HR and saying someone is sleeping at work, and everyone's instinctive reaction is to think how dreadful. Right from your anesthesiologist example at the worst end of the spectrum. At the other end of the spectrum, however, you might have the person sleeping at work, maybe someone doing a night shift in a care home where they're perfectly entitled to sleep at work. So that's an extreme example, but it does show to you that context is really, really important in a majority of offences. So the final question is, it's like a post-dismissal question. What are our obligations from an immigration perspective if we dismiss an employee for misconduct where the employee is sponsored by our business on a Tier 2 or skilled worker visa? So first of all, the business must comply with normal employment law practices and procedures when dismissing a migrant worker to avoid discrimination on fair dismissal claims. If a business stops sponsoring a migrant worker for any reason, for example, the employee is dismissed for misconduct, it's your responsibility as the employer to inform the Home Office of the termination of the employment and the sponsorship. And you must do that within 10 working days of the employee's final day of employment. And that's done by online via the Home Office sponsor management system. And as part of that process, you'll need to provide the employee's last known home address or contact details as part of the report. And Kirsty assures us that this is the end of your obligations from an immigration perspective in relation to that employee. And what happens next is that normally on receipt of the notification, the Home Office will send a letter to the employee explaining that their leave or permission to remain in the UK will be curtailed. Once the employee receives that letter, they will have 60 days or until the end of their current visa, whichever is the earlier, to find a new employer or leave the UK. So a bonus immigration answer at the end of our session today.
Thanks, Charles, and thanks to Kirsty, who's our head of immigration, for helping us with the answer to that one. So that's the end of the session. Like I said, no questions in the chat box today. Thank you all for joining us. We haven't actually set a topic for our next session, which will hopefully be next month. So if you did have any ideas, feel free to drop us a line, and we'd love to take that on board so that we can address issues that you're facing in practice. But for now, thank you very much, and we hope to see you next month.